This is the hearing of ex-sheriff Jamie Knoll.
Your initial hearing. For the record, would you state your full name?
Jamie John Knoll.
If you have a cell phone, please turn it off or put it on silent. If it disturbs the proceedings, you can have it confiscated and imposed a fine for other sanctions. The second thing is, if you have recording devices, if you have not been approved by the court administrators on allow, please turn it off. Once again, if you do not, you do something still priority, and I will have to confiscate it and to incarcerate you. Date of birth?
12/18/70.
And that will make you how old?
52, sir.
And the last four digits, your social security number?
3001 Old Bay Bridge, Jeffersonville, Indiana.
You have a good contact telephone number?
Yes, I do.
What is it? Are you under the influence of any drugs, including alcohol today?
No, Your Honor.
Or even understand English language?
Yes, Your Honor.
If I say something you don't understand, will you let me know?
Yes, Your Honor.
Mr. Knoll, Special Prosecutor Pearl has charged you with 15 counts of criminal conduct. And I'll go through it. Count one. Corrupt business influence is a level 5 felony. It would indicate that pursuant to Indiana Code 35-44-1.1-2-1, that on or about a period of time from November the 9th, 2018 and August the 16th, 2023 in Clark County, state of Indiana, you did knowingly or intentionally through a pattern of racketeering activity acquire or maintain, either directly or indirectly, an interest in or control of property or enterprise contrary to the form of a statute in such case made and provided. Count two, theft as a level 5 felony. It would indicate that pursuant to Indiana Code 35-44.1, 2-1, that on or about May 3rd, 2021, in Washington, Clark County, state of Indiana, you did knowingly or intentionally exert unauthorized control over the property of Utica Volunteer Firefighters Association, that being Utica, with the intent to deprive Utica of any part of the use or value of the property. Said property having a value of at least $50,000. That being on May the 3rd, 2021, you traded a Utica-owned 2020 Chevrolet Corvette with a specific VIN number valued at $92,000 for a 2020 Mercedes-Benz S-Class 450 with a specific VIN number, and registered said Mercedes in your own name. Count three, theft as a level 5 felony. Pursuant to Indiana Code 35-43-4-2A, would indicate that between January the 2nd, 2019 and October the 10th, 2019, in Clark County, state of Indiana, you did knowingly or intentionally exert unauthorized control over the property of Utica Volunteer Firefighters Association, that being Utica, with the intent to deprive Utica of any part of its use or value of the property, said property having a value of at least $50,000, that being on January the 2nd, 2019, you traded a Utica-owned 2017 Chevrolet 3500 Silverado for a 2019 Challenger SRT Hellcat with a specific VIN number and titled said Hellcat in your own name on October the 10th, 2019. You then personally sold said Hellcat for $83,000, $83,716. Count four, theft is a level 6 felony under Indiana Code 35-43-4-2A. Would indicate that between April the 30th, 2021 and September the 14th, 2022 in Clark County, state of Indiana, you did knowingly or intentionally exert unauthorized control over the property of Utica Volunteer Firefighters Association with the intent to deprive Utica of any part of the use or value of the properties, that said property having a value of at least $750 and less than $50,000, that being on April the 30th, 2021, you traded a Utica-owned vehicle in for a 2012 Porsche Panamera, with specific cause number and title said Porsche in your own name, that on September the
Okay, people, let you know what the Indiana Sheriff, there's 92 counties in Indiana. They get a salary. And when you all file for divorce or protective order, he gets something like that. Under another sheriff years ago, Buddy Parker, who was the chief of police of Jeffersonville, Indiana. First year, I think he told me he made $1.5 million. So why did he have to steal all that taxpayers' money from the fire department? His bond should have been $500,000 and his wife should have been $300,000. Let's get on with the video.
2022, you sold said Porsche for $32,000 to a car dealership and deposited said funds into your own personal account on September 14, 2022. Count 5, theft as a level 6 felony, would indicate that between December the 2nd, 2020 and September the 28th, 2022, in Clark County, state of Indiana, you did knowingly or intentionally exert unauthorized control over the property of Utica Volunteer Firefighters Association, Utica, with the intent to deprive Utica of any part of the use or value of the property, and property having a value of at least $750 and less than $50,000. That being, on December the 2nd, 2022, you traded a Utica-owned vehicle in for a 1957 Chevrolet Bel Air with a specific VIN number and title said Chevrolet in your own name on September the 27th, 2022. You sold said Chevrolet for $39,500 to
That's cheap.
Eubanks and deposited said funds into your own personal bank account on September the 28th, 2022. Count 6 theft would indicate that between August the 31st, 2022 and September the 14th, 2022 in Clark County, state of Indiana, you did knowingly or intentionally exert unauthorized control over the property of Utica Volunteer Firefighters Association with the intent to deprive Utica of any part of the use or value of the property, said property having a value of at least $750 and less than $50,000. That being, on August the 11th, 2022, you took a Utica-owned Kubota HST tractor purchased in 2017 for $40,600 and sold it to James Bishop for $31,000. On September 14, 2022, you deposited the check for $31,000 into your own personal bank account.
I guarantee people, this is dumb. You know, this is a screw up case. If that was me or you, we still be in jail. You know, this is not right. His ass should be in jail. No bond.
Count 7, obstruction of justice as a level 6 felony, would indicate that on or about August the 16th, 2023, in Clark County, state of Indiana, you did knowingly or intentionally alter, damage, or remove any record, document, or thing with the intent to prevent it from being used, produced as evidence in any official proceeding or investigation. That being, you factory reset your phone upon the arrival of the Indiana State Police on your property. Count 8, ghost employment is a level 6 felony. It would indicate that between November the 9th, 2018 and December 31st, 2022 in Clark County, state of Indiana, you, in your capacity as Clark County Sheriff, public servant, did knowingly or intentionally assign to Michael Bowling, an employee under your supervision, duties that were not related to the operation of the governmental agency that you serve, that being sheriff assigned Bowling duties on your personal property, rental properties, father-in-law's properties, pole bar, and property of Utica Fire Department. Count 9, ghost employment as a level 6 felony, would indicate that between November the 9th, 2018 to December 31st, 2022 in Clark County, state of Indiana, you, in your capacity as Clark County Sheriff, public servant, did knowingly or intentionally assign to Donald Jones, an employee under defendant's supervision, duties that were not related to the operation of the governmental agency that you serve, that being sheriff assigned to Jones duties on your personal property, rental properties, father-in-law's property, pole barn, and property of Utica Fire Department. Count 10, ghost employment as a level 6 felony, would indicate that between November the 9th, 2018 and December the 31st, 2022 in Clark County, state of Indiana, you, in your capacity as Clark County Sheriff and public servant, did knowingly or intentionally assign to Rodney Walker, an employee under your supervision, duties that were not related to the operation of the governmental agency that you serve, that being sheriff, assigned Walker duties on your personal property, rental properties, father-in-law's property, pole barn, and property of Utica Fire Department. Count 11, ghost employment as the level 6 felony, would indicate that between November the 9th, 2018 and December 31st, 2022, in Clark
There is
County,
Larry
state of
Wilder.
Indiana,
He is attorney
you,
for
in your capacity as
Jacksonville.
Clark County Sheriff, a public servant, did knowingly or intentionally assign to Brent Fisher, an employee under your supervision, duties that were not related to the operation of the governmental agency that you serve, that being a sheriff assigned Fisher duties on your personal property, rental properties, father-in-law's property, pole barn, and property of Utica Fire Department. Count 12, official misconduct as a level 6 felony, would indicate that between November the 9th, 2018 and December the 31st, 2022 in Clark County, state of Indiana, you, a public servant, that being sheriff of Clark County, knowingly or intentionally committed an offense in the performance of your official duties, that being ghost employment of sheriff of Clark County relating to Mike Bowling. Count 13, official misconduct as a level 6 felony. It would indicate that between November the 9th, 2018 and December the 31st, 2022 in Clark County, state of Indiana, you, a public servant, that being sheriff of Clark County, knowingly or intentionally committed an offense in the performance of your official duties, that being ghost employment as sheriff of Clark County relating to Donald Jones. Count 14, official misconduct as a level 6 felony, would indicate that between November the 9th, 2018 and December 31st, 2022 in Clark County, state of Indiana, you, a public servant, that being sheriff of Clark County, knowingly or intentionally committed an offense in the performance of your official duties, that being ghost employment as sheriff of Clark County relating to Rodney Walker. And count 15, official misconduct as a level 6 felony, would indicate that between November the 9th, 2018 and December the 31st, 2022 in Clark County, state of Indiana, you, a public servant, that being sheriff of Clark County, knowingly or intentionally committed an offense in the performance of your official duties, that being both employment as sheriff of Clark County related to Brent Fisher. Mr. Dahl?
You know, that's bad. You know, it's bad. You know, how can an idiot do something like that? Steal from we the people. We the people of Clark County. It's still going on in Clark County, in the courthouse. The new sheriff, Scotty Maples, he had to know about this. He was his number 2 deputy. He was the chief deputy under him. It's still going on today. A week or so ago, I saw a county sheriff pickup truck, a white one. I think maybe it was a Dodge. Behind that was a white van, maybe 80s or 90s. It's an old type van, white one, and a black trailer. They were going eastbound on 62. I don't know where they was going, but they passed Charlestown like they're going towards New Washington, maybe Bethlehem. And I guess because, you know, that's farm country. You know, that's only my opinion. That's not the first time I've seen that white pickup truck driven by a deputy. And the one driving the white van was a deputy. It had a light up on the dash as an unmarked unit in the van. So let's get back to it.
Well, the first 3 counts are level 5 felonies, which have a range of imprisonment from 1 year to 6 years, with the advisory sentence being 3 years and up to a $10,000 fine. Counts 4 through 15 are all level 6 felonies, which have a range of imprisonment of no time in jail if treated as a misdemeanor to 2.5 years at the Indiana Department of Corrections.
I hope he gets prison time, but he knows
up to a $10,000 fine.
Okay, as being sheriff and an ex-state trooper, he knows a lot of secret stuff, you know, on important people that never did get arrested. So, you know, this is the WTSC News. I'm going to call it Channel 11, my news station in northern part of Clark County. You know, what somebody got to do with it? Clark County is bad corruption, period. But Scotty Maples had, like I said, he's involved in this somehow. You know, so it's just wait and see. But they got a total of 25 charges. That might be a part 2 to this to show this. He got a total of 25 charges. He used the fire department's money to pay his child support on a child that he had by a county council woman. He failed to report it on his taxes and gave her a car, which the fire department paid for. He never reported. You know, there's a lot more going on here that they letting out. Let's get back to the video.
Do you understand what you've been charged with?
Yes, Your Honor.
Do you understand the potential penalties?
Yes, Your Honor.
The next question is usually, do you intend to hire a lawyer to have counsel seated with you? I need to tell you, you have a right to a speedy public trial by jury in this county. You have the right to face all witnesses against you, severe question and cross-examine witnesses. You have the right to have witnesses brought into court to testify on your behalf. And at your request, the court will issue subpoenas requiring those individuals to come into court to testify on your behalf or to bring evidence. You have the right to have the state prove you guilty beyond a reasonable doubt. You have the right to remain silent. You cannot be required to give any testimony or make any statements against yourself to anyone. You do have the right to be heard in your own defense at any hearing or trial concerning the charges against you. Anything you say, however, may be false against you. Do you have any questions concerning your rights?
No, Your Honor.
Okay. Now, by agreement of the parties, I'm going to enter a preliminary plea of not guilty for you and set this matter for a pretrial conference date on January the 8th at 1 p.m. At that time, we will also select an anonymous date. There will be a jury trial set for May the 6th, 2024, starting at 9 a.m. Do you have any questions?
We have none, Your Honor, thank you.
It's a
All right,
month
now-
away.
The next issue is, State of Indiana asked that you be held without bond, at least till the initial hearing. So I now want to take up the issue of bond. Mr. Hurdle?
Thank you, Your Honor. The state would ask the court to consider, and I believe it is required that the court consider the factors set forth in 3533-84, the amount of bail, entry of order, endorsement on warrant in lieu of order, factors relevant to risk of non-appearance. So the state would ask the court to take a look at that. Specifically, the state points the court to subsection 7, the nature and the gravity of the offense and potential penalty faced. The defendant, as the court just read, is subject to 15 counts, 15 felonies, 3 of which are level 5 felonies, 12 of which are level 6 felonies. The state believes the gravity and the nature of the offense is significant here and would ask the court to consider those in determining his bail today. The state would also cite a couple of things as risk of non-appearance. The defendant has a home in the state of Florida. Does the state have any evidence that he's going to flee or run to the state of Florida?
Okay, people, I got a question for the Indiana State Police and the FBI. Have they searched that house in Florida? You know, that's my question. And for you people here, have the FBI or the Indiana State Police searched that house? I haven't heard anything on that yet. You know, it's only my opinion and my butt.
No evidence of that, Your Honor, but I do believe it's important for the court to at least consider that there is a home there. The state would also point out that the defendant owns his own plane and has access to a plane that certainly allows him to come and go outside the state of Indiana at his leisure. The state would also point out that the defense has filed a brief on the defendant's bond or recognizance conditions, and outlined in that brief, it does specifically say, in fact, he voluntarily availed himself of the court when he became aware that the Indiana State Police had potentially secured a warrant for his arrest. He traveled with his attorney, Larry O. Wilder, to the courthouse and waited in the Circuit Court 1 for multiple hours, presenting himself voluntarily at the lobby of the Clark County Jail. The state doesn't dispute that, Your Honor, but I think that only tells a snapshot of the story that happened yesterday, because I agree with part of it. The state police were waiting for a warrant to drop after the charges were filed yesterday, and in fact made contact with him in an attempt to basically locate him. They followed him for a period of time. Flee might be a strong term, but he certainly went to the state of Kentucky and attempted to elude them for a significant period of time, ultimately parking his vehicle on the street in Louisville, getting into a car with his attorney in Kentucky. So I think that adds a little bit of a difference and a different flavor than what the defense posed, that he's basically sitting in the courtroom here waiting and then turning himself into the lobby, because earlier in the day, he's running from the Indiana State Police, bouncing around in a truck in Indiana and then to the state of Kentucky. So I think the state should consider that as well in determining his bail. The state is not in possession of any IRAS. I know he was evaluated today. I believe the statute does require the court to consider the IRAS as well. Okay, thank you. And I would ask the court to consider whatever that might be, Your Honor. Further, the state would ask the court to consider if and when the defendant posts bond, that he be placed on some sort of monitoring device, whether that be a bracelet of some sort.
I agree with it. He should have a bracelet on to know where in the heck he is. You know, him being an ex-state trooper and the ex-sheriff of Clark County, Indiana, should have that bracelet. If that was you and me, people, we would do that. They would make it mandatory. To me, I think he's getting special treatment.
Some sort of in-home incarceration, work privileges, or something of that nature. And if the court is maybe not inclined to do that, then a day reporting of some sort to the probation department or court services here in Clark County, or court services in a neighboring county because of the connections the defendant has here in Clark County. And lastly, Your Honor, the state would ask the defendant to turn over all of his weapons to the Indiana State Police so that they may be kept. As subsection B points out, defendant could pose a risk to the physical safety of another person or the community. The state is aware that pursuant to the search warrant that was executed in August of this year on at least one of his properties, there were a multitude of weapons that were there. The state did not seize those weapons as there was not a warrant for those and he was not illegally possessing those that the state is aware of. But in factoring bond, and once he does post bond, those weapons the state believes ought to be turned over to the Indiana State Police for safekeeping as well. All that being said, Your Honor, the state would ask for a bond in the amount of $25,000 to $30,000.
That's too cheap.
Posted by cash by the defendant. The state believes that is reasonable under these circumstances. And again, asking the court to review the factors set forth in Indiana Code.
I think the bond should be in $500,000. $25,000 to $30,000 is too cheap for an ex-sheriff, ex-state Indiana State Police trooper. One thing about police officers, they know where to get fake passports. They know where to get fake IDs. He's still a flight risk. I don't care, I disagree of them posting a bond. You find out how much the bond is and you all will fall over. I couldn't believe it.
Along with the IRAS and those that the state just laid out for the court today.
Mr. Earl, you indicated there was a multitude of firearms. What kind of firearms were they? And
One moment, Your Honor.
approximate number.
Your Honor, in talking to the detective who is handling and overseeing this investigation, assault rifles, shotguns, and handguns as well, Your Honor. Thank you, Judge.
The state rests and the argument.
I suspect on what's rebuttal, but
Listen to this
for the
crap.
time being, Mr.
Certainly,
Always
Judge.
your turn.
So first, Judge, we all know that bond issues require evidence, and as we know, what lawyers say is not evidence. I've seen no evidence. We call Chris Tinman to the stand, Judge.
This guy, he works for the probation department. Clark County is different from Washington County, Scott County, or any other counties in Indiana. Jamie Knowles should be classified as level 1 in my book.
Solemnly swear or affirm I will faithfully fulfill your testimony about the truth, the whole truth, and nothing but the truth. Yes. That's it.
Thank you, Judge.
For the record, tell me your name.
Chris Tidman, Tidman, and I'm with the Pretrial Services Corporation.
You can answer. So, your professional address,
501 East Courthouse.
Jeffersonville.
Mr. Tinman,
Counsel's question.
I'm sorry, thank you, Judge. Mr. Tinman, can you tell the judge what your qualifications are that provided you with the ability to provide pretrial services in Clark County, Indiana?
I've been with pretrial services for 4 years. I have a Bachelor of Science in Sociology, as well as training through the Indiana state government
And that's training in providing,
for the Indiana risk assessment.
so when we say IRS, we're saying Indiana risk assessment, correct? So to prepare your Indiana risk assessment in this matter, did you review the CCS chronological case?
Yeah, we do a limited background check as well as conduct an interview with the defendant to come up with the IRS score.
And we agree that when you looked at the charges filed, Mr. Dole is not charged with murder, correct? Nor is he charged with treason, right? Which are non-bondable offenses in Indiana, right? The only way you can keep somebody in jail without bond in Indiana is they're charged with murder or treason, correct? And in fact, when you reviewed his criminal history, you determined, or did you find that my client has ever been charged with a crime in Indiana?
I did not locate any involvements. There was one very old involvement that was abolished, but other than that, there was no.
Traffic infraction.
Right.
So he has had a traffic infraction in his life. And when you reviewed the information and got the evidence together to provide this information to the court, did you notice whether he was on probation or parole from any unrelated offense?
He's not currently on any active supervision.
So you're familiar with Indiana Trial Rule 26, correct? Which is what makes you have to do this, right? So in considering your recommendation.
But the thing about that, they don't do it that quick. They usually take a couple of weeks to do it, maybe a month, but not this quick. No way in form. That is too quick. I wonder why this is so quick. You know, maybe the ex-sheriff got something on him. Possible. I don't know. That's just a figure of speech, people. Let's get back to it.
Or what the IRS says. The reasoning should be that no bond for arrest, or excuse me, for murder or treason, correct? Doesn't apply, right? No bond for someone who has pre-trial detention in other places or is on probation parole, correct?
Yes.
Doesn't apply. And that you review whether or not that this new offense has something to do with any other old offense, correct?
Yes, all those factors combine into the.
And none of them apply to Mr. Dole.
He scored a low on our IRS.
And how low can you go on an IRS and be the lowest you can be?
It would be a 0.
And what is Mr. Dole's score?
He scored a 0 on our IRS.
So, based upon what Indiana Supreme Court's adopted through this trial rule, which is evidence, right, that the finding is that he had a 0 risk of flight, correct?
He would be a low risk of flight. He scored a 0 on the IRS.
And with having scored a 0, we agree that the Indiana pretrial release rule says that he should be released on his own recognizance, correct?
Yes, and I put him as a level 3 on the supervision.
And what's level 3 supervision, so Judge Medlock understands, because he's coming from.
Okay, my question, how much does that guy get for doing this? He had to get paid underneath the table. You know, it's only my First Amendment opinion, people. I'll leave it up to you that specialize in this field. You know, every state's different, so let's get back to it.
For Washington County, we have different things here. What's a level 3?
I'm from the country.
Yeah, that's not correct, Judge Washington County.
Level 3 is our lowest level of supervision.
Which is what?
Is 1 monthly contact with an officer in person.
Now, you heard the government's argument through its special prosecutor as to what they recommended the detention be. Could you enlighten us all as to what he's asked for? What level would that be of supervision?
Right now, currently, we don't do any HIP, but that would be level 1, which would be the most restrictive.
And what is, when somebody's on the most restrictive type of pretrial release, in your experience and based upon your time doing what you've done, what are the crimes that usually constitute that?
It would more so be with any past pretrial FTAs, or a risk of if they don't have a stable residence and things like that would be more so related to the amount of contact that we would like to have.
So what he's asked for is the highest, which is for the most prominent criminal offense and criminals, correct? And what he grades is the lowest, which is 0.
Yeah, he's
And that's the evidence,
he's
right?
pretty low, yes.
And that's the evidence. And you were aware that Mr. Knoll and his lawyers waited until there was a warrant signed, correct?
I'm not aware of that.
Okay, then I have no further questions, because that would not be evidence, because you don't have personal
Yeah,
knowledge.
yeah.
Judge, I would move in the IRS as evidence as it relates to what bond should be, and we would just ask that the law set out criminal trial law 26 be followed, and that our client be released on his own recognizance at the level of supervision that seems to be appropriate based upon the evidence presented by this witness who's qualified to testify.
Any objections to the admission?
No, Your Honor, no objection.
I'll show. Made it is. Defendant's Exhibit A?
Yes, Your Honor.
Accepted. Cross-examination, Mr. Herbal.
Mr. Tidman, I guess maybe I don't fully understand, or maybe in Ripley County, we use the IRS for something different. Is it your testimony that if someone scores a 0, they should be released on their own recognizance each and every time, no matter what the charge?
No, sir, I
Okay,
don't
because
have.
that's what I got.
Judge, could he answer? He wasn't finished. He asked a question. Can he answer?
Sit down,
It
Larry.
is an objection. He cut the witness off and he wasn't finished answering.
Response, Mr. Herbal.
I'll withdraw the question.
Thank you.
Ask it again, Your Honor.
You may.
So all due respect, I'll repeat the question, Mr. Tidman. Is it your testimony today that if someone scores a 0 on the IRAS, the court should just release them on their own recognizance?
No, sir, that decision is up to the judge. I can only simply make an IRAS recommendation and a supervision level recommendation.
And so you're not saying bond should be 1,000, 5,000, 10,000. You're talking about once bond potentially is posted, what the supervision level you're at least recommending?
Through our pretrial services program, you could be released on your own recognizance to pretrial. You could have a bond and then report to pretrial as well.
Okay. Now, who employs pretrial services in Clark County?
Could be the Clark County government.
Okay, so who do you report to?
Who do I report to? The chief probation officer and then the judges.
Okay. Do you work with the sheriff's department at all?
Directly in the mornings, they get together our defendants for interviews in the morning. But as far as like face-to-face, not daily, but we.
That's a lie. I know somebody, and they did meet face to face. Confidential source. They want to be protected. He just committed perjury there in my book.
Do communicate with the jail every day to get our defendants for interviews.
So they provide you information and access to their inmates?
They provide us the ability to talk to the inmates for the CR 26 interviews.
Okay. And you said you've been employed for 4 years?
Yes, sir.
And during those 4 years, was the defendant the Clark County Sheriff at that time?
Yes, sir.
Okay, so you had received permission, at least at some point in time, from him or his employees to access those same different defendants for the IRS, is that right?
I've never personally communicated with Mr. Knoll, to my knowledge, but I do communicate with his staff through the jail, through the interviews.
And obviously, just like the staff now reports to Sheriff Maples, at one point in time, that staff reported to then Sheriff Knoll. Do you feel comfortable supervising somebody like Mr. Knoll?
Judge, I don't object to the characterization of the question. somebody like Mr. Knoll? Are we talking somebody that scores a 0 on the IRS? What are we trying to imply? Somebody like Mr. Knoll?
State the objection, Mr. Lawyer.
I object.
Hey, Larry, sit down. I know you're making enough money on this from the illegal money that he stole from the taxpayers of Clark County, Indiana. Sit down, Larry.
Check the characterization of the question. It implies something that is nefarious as it relates to my client. There's no evidence. There's still no evidence from the state of anything.
Response, Mr.
Your Honor,
Okay, people, if you look up Larry Wilder, the lawyer, it's somewhere on one of the local TV stations. He was drunk, and they found him inside of a garbage can where he lived. That was quite a few years ago. He probably got set up or somebody put him in there. I believe Jamie Knoll was the sheriff back there then, but I'll leave it up to you all. You can look it up on the internet. One of the TV stations, I forget which it was, they found Larry Wilder drunk inside of a garbage can. I've been drunk before, and I know you all have. Have you wake up in a garbage can? That's weird. Let's get back to it.
no attempt to be nefarious. There was an attempt basically to ask him if he felt comfortable supervising the ex-sheriff in Clark County.
Overruled demands.
Thank you, Judge.
I understand what you're asking. I don't personally
I think too. I think
supervise.
Mr. Wilder did too.
I do the assessments. So in terms of me personally supervising him, I wouldn't be in that role. But I understand what you're asking, and I wouldn't really have an opinion on that one way or another. If I was asked to do something, that's what I'm asked to do.
So that might be a question for one of your superiors, the chief probation officer, or someone else, how they would feel about supervising someone like Jamie Knoll.
That would be a question for the chief probation officer on how they would like to handle a former employee of the Clark County government branch being supervised.
Above your pay grade.
Yeah, if you want to phrase it like that, sure.
At Laura Buick GMC, buy online truly means buy online. As the #1 volume Buick GMC dealer in
Do you know the defendant?
Just as the sheriff, but not personally.
Do you have any personal knowledge of any of the accusations made in the criminal information against the defendant?
Just what I did on a report from copying the charges over.
Have you all been pretrial services here?
Yes, sir.
You live in Clark County?
Yes, sir.
Was any of this a surprise to you?
Judge, I'll check. Relevance.
Sustained.
Thank you, Judge.
I don't believe I have any other questions at this time.
Just one, Judge. Was there anything that Mr. Hurl asked you that caused those findings on that piece of paper to change?
No, sir. What I put on the paper is what he scored.
Thank you.
To me, that's a lie. It does matter what's on those papers. You got inmates that's in the Clark County jail don't have those type of charges, maybe drugs or alcohol or PI, DWI, like that. Something don't make sense here.
No question.
Court has a question. Yes, sir. Hello. Besides this one, how do you pronounce your last name? Tibman. Tibman? Yep. Mr. Tibman, how many times have you done a pretrial assessment on a past public official and a current, public figure that has an airplane and that allegedly has a lot of other people's money and government taxpayer.
This would be a unique
It'd
situation.
be a unique situation.
You could tell the
That prompts
judge
a
ain't
question
happy.
from your son.
Not from the state, Your Honor.
I am no judge, thank you.
Thank you.
I think you can step in. Any other witnesses, Mr. Bowman?
Your Honor, at this time, we've provided all the evidence that's necessary, we believe, to support our argument, which is trial 26.
Mr. Bowman, I was given your brief just moments before I came out here. Would you like to summarize it for me?
Your Honor, there's really no need to summarize the brief because what really matters is the government provided zero evidence. Lawyers' words are not evidence. Statements that Mr. Hurley made are not evidence. We do evidence-based bonds now. The trial rule is clear, the statutes are clear. The only evidence before the court today is what we heard from the gentleman who's trained to make that determination as to what his IRS is. The only thing we follow based upon that is what the Supreme Court of Indiana has told us we follow. Trial Rule 26. He is not charged with murder. He is not charged with treason. He was not on pre-trial release for an unrelated matter. He has never been arrested, and he is not on probation or parole or under a community supervision program. The Supreme Court states that the IRS indicates that he is not a risk of flight. Therefore, we ask the court to place him on level 3 supervision and that he be released today on his recognizance.
No way.
Mr. Hurley?
Hell
Your Honor,
no.
the state would rest on its prior evidence that was placed before the court in the my first round. I think probably to clear up the record, the state has no issue with Mr. Tidman and pretrial services in Clark County. I think the state is trying to be cognizant, as the court is, of potentially supervising an ex-sheriff, a public figure, someone like Mr. Knoll, no nefariety noted there either. But if Clark County is in a position that they want to supervise, and if the court feels that ultimately after bail is posted, the pretrial services in this county are most appropriate, then by all means do it. But I think that there certainly could be some at least perceived conflicts. Hence, that's why the Indiana State...
There's his daughters, and you see his wife there, got the black hair. That's his daughters. One of them got arrested.
...intent that the state was doing that. Nothing personal or untoward with Mr. Tidman. So the state would ask the court to consider that in any determination it makes today with respect to bail.
I had no concern with Mr. Tisdale in regards to his veracity or the assessment. Mr. Waller, did you want to say that?
Judge, I was only going to once again state the only evidence in this hearing today is the testimony from Mr. Tidman and the document that was put into evidence. Nothing we say as lawyers is evidence. They presented no evidence. That is the burden they had, to present evidence by preponderance of the evidence, to ask you for anything more that he be released on his own recognizance.
I disagree with the people. If it was you and me, if the prosecution, if that's not evidence, how come there's people still in jail waiting for court dates? This like that. Why come they're in the county jail, or why are they in prison if that's not evidence? Can you all explain it to the people? It's on YouTube. 'Cause that don't make any sense. He looks like he's worried.
Should fly that passport.
He does, but I think it was, do they read your passport? He does have a passport, and we will turn it in, Judge.
One would think about it, at least a short time before I issue a ruling in regards to the bond. there's at least one other issue that I need to address in a different cause number. We need to do something technically to address that. We can continue in this cause number, or in this recording.
Yeah, that's fine.
All right. Cause number 10, C01-2307, MC 11423, that being in the matter of the investigation by the Indiana State Police. I was also handed this not too long ago. There was a motion to unseal the records in regards to the investigation. Mr. Wilder,
We have no objection, Judge. We welcome the unsealing of all those documents for the public and for us to have an opportunity to read.
all right, then I'll order that matter to be unsealed. So I expect the clerk in the court will have a feeding frenzy from the media here in a short period of time. Mr. Hurdle, is there anything else that needs to be addressed today?
Now, from the state, Your Honor, is the court's intent to take a brief recess and make a decision, or are we going to adjourn for the day?
I'm gonna take a brief recess. I'm gonna take a brief recess, then I'll decide whether we're gonna adjourn for the day.
Thank you.
Just stick around. Mr. Wilder?
And Judge, so long as our client remains here and he's not transported back to Scott County, why would we wait for your determination that would be?
Well, I'll decide that in a few minutes.
Yes.
And just for the public's knowledge, I was assigned to the special investigation, and I signed, as I'm sure a lot of folks know, the search warrants and subpoenas. Because it was a new case file, the setting judge had to recuse himself, and I had to wait until I received notice from the Supreme Court that I had been assigned to this particular case. That notice came at about 10 to 4 yesterday afternoon, and thus I could not assume jurisdiction or take any action in regards to the issuance of the arrest warrant until that occurred. And that's one reason Mr. Wilder and Mr. Nolan sat in the gallery for a period of time, and I assume if he had been arrested in Kentucky, it would have been probably a week before he could have been extradited. So it's probably good advice you give him to get back to Indiana, Mr. Wilder.
We met at Mr. McMahon's office to come to Indiana for the purpose of making sure we afforded ourselves the jurisdiction of the great state.
Look at that smile on his face.
Mr. Wilder,
Nothing changed.
I'll be off record for a few minutes while I think about
Thank you,
what
Judge.
I need to do.
We're going to. Dollars, but that money obviously has been put in my trust account. Therefore, I will be. Is it sufficient to sign a trust check from my trust account to cover the?
The bond was $75,000 full
Walking
cash.
around with $75,000 in cash bothers me, Judge, and it all went into the bank.
I'm not sure what I don't have any concerns with your trust check, Mr. Wilder. I don't know what the policy is for the
They accept my trust checks, Judge.
Mr. Hurley, in regards to the issue of the inventory of the firearms, what's your position?
Your Honor, the state is prepared to accept those either from the court to the state police or directly to the state police. I believe that either one is appropriate. If it's going to assure him some peace of mind that something's not going to be damaged, the state probably would contend that there was nothing returned to him damaged, but that's for another day, Your Honor.
Mr. Waller, I don't know that the court has the ability to do inventory the firearms. I don't know how many firearms he has.
Judge, could we allow the Jeffersonville Police Department to inventory the firearms, photograph the firearms, and then transfer them to the state police?
I don't have jurisdiction over that.
If the Jeffersonville Police would do that, Judge, is that sufficient?
No. Here's what you may do.
Yes, sir.
When they're surrendered, have someone from your team be there to monitor.
Yes, sir.
Take photographs of them as they're surrendered to show the condition that they're in. That's fine.
Yes, sir.
You can do it one by one. When can that be accomplished? And Mr. Dalton,
Yes, sir.
you keep one shotgun only. Try to deceive me, you will not like the consequences. Understand?
Yes, sir.
And then, Judge, the issue of return of all other items seized, we can just take it in another hearing?
Well, it wasn't set for today, so
No,
yeah, we'll deal with that at another time. I assume, now that everything's gonna be unsealed, there'll be a lot of new things brought before the court that
Yes, sir.
we'll address in due time.
Thanks, Judge.
Anything else?
No, Your Honor.
Nothing else from us, Judge. Thank you.
All right, we'll be off record. Thank you all.
So after the hearing, the special prosecutor held a press conference to kind of
So I want to thank you all for joining my live stream. Hit the thumbs up, hit the notification bell, subscribe to my channel. You know, that's what I'm asking you all to do. There's more videos on ex-Sheriff Jamie Noel, his wife, his daughter. You can find them on YouTube. Type in Jamie Noel. You have your local TV stations. I'm asking you all to help me out on subscribers. And I'm using StreamYard. You know, how can I do this on StreamYard? You know, present and share it, and it'll pop up on my screen like I see the DUI guy, Megan Fox, the writer, MG Law, the expert. How you all do that? You know, can you all help me figure this out? You know, let's see if this one beats 200 views. You know, this is in Clark County, Indiana. You can look on the county map. And you see Scott County. You see how small Scott County is. It's up the road from me. So, I want to thank you. Hit the subscribe bell. Help me out on my subscriptions. You know, let's get over. I like to get 1,000 subscribers out of this video, but it's not. I like to see the DUI guy, Megan Fox, MG Law, the expert. I like to see them do this. You know, do a segment on this. You know, they know how to bring up everything, and they know how to do it since they're using StreamYard. I want to say have a good weekend. Have a great Sunday, since this is Sunday morning. Don't forget about the eclipse Monday. Wear your glasses for that. This is Tom Cartwright, 4375 in Northern Clark County, Indiana. Bring you some good corruption in Clark County, Indiana. It's still going on. So I want to thank you all for joining my YouTube channel and subscribing to my YouTube channel. I love you. Peace. Aloha. I love you all. Goodbye.